Court will come to order. Mr. Harden will try to wrap by about 6:30. If a good breaking point, if it's a few minutes later, fine. If it's a few minutes sooner, I'll leave it to you.
There you go. Thank you.
We'll wait for our witness here.
The necessary participant. Now, if you can keep the microphone to you, my problem is I can hear you sometimes thinking, I think you're perfect where you are. All right, we move on now from the open records. In your mind, does the issue die out as to that file after your conversations, repeated conversations with the AG? Oops. Is that got what?
Testing.
Yes.
Yes. The issue did eventually, from my perspective, die out. It was not raised again for some time, for a matter of months after that.
Did it resurface later that year?
It did.
And how and when?
I was promoted to a different role in March. I believe it was March of 2020. So as COVID was kicking in, I was promoted to Deputy First Assistant Attorney General. So the role that Brantley Starr previously had, he had been elevated to the federal bench, and I was asked to assume that role. So Ryan Vassar became the Deputy for Legal Counsel, which was the role that I previously had been serving in. But I was aware, because I was working with Ryan Vassar at the time, helping him to learn the ropes of open records, that another request had been submitted, this time to DPS.
Stacey, can you pull up back the first demonstrative we started the trial with? It lays out the pictures of everybody. Thank you. Can you see that okay?
Yes, sir.
Can you see that okay? So, does that accurately reflect where you were in the new lineup?
Yes, it does.
All right, I'm going to call this demonstrative 1. And this particular document, whom did you report to? Did you have a direct report to the Attorney General or to Mr. Mateer?
I reported directly to Mr. Mateer.
And then how many divisions did you have under you by this time?
I was still overseeing the Special Litigation Unit, but apart from that, I had no other direct reports. However, as the Deputy First Assistant, I was assisting the First Assistant in overseeing the agency as a whole.
So if the First Assistant was out of town, would you be the one that would be essentially the acting First Assistant?
More or less. When he was out of town, I would assume some of his responsibilities as a matter of practice. I also would handle duties as assigned by both the First Assistant and the Attorney General.
And you, by this time, had known Mr. Mateer how long?
Several years.
All right. Had you ever seen or known him to express any interest in ever being the Attorney General himself?
No, I had not.
All right. On a scale of 1 to 10, 10 being totally absurd, 1 being much less than that, where would you rank?
In terms of his desire to become the Attorney General, he was very tired. By the end of his 5th, he was going into his 6th year, and he had expressed to me, especially toward the end, how he was thinking about retiring from public service because his back was bad. He had been burning the candle at both ends for some time.
So on a scale of 1 to 10 again, in terms of his desire, your observations to be the Attorney General, where would you rank it?
It would be 0.
All right. Thank you. Now, let me ask you this. How did the continued issue of the open records request and desire to obtain open records concerning Mr. Paul's search warrant and criminal investigations again, how did you next come into contact with it and when?
Speaking with Ryan Vassar, who by that time, April, May of 2020, he was overseeing open records as the Deputy for Legal Counsel. I understood that a request had been filed, I believe it was with DPS, for additional materials relating to the Nate Paul investigation.
All right. And the original time that you became aware of Mr. Paul seeking these records, whom was the open records request directed to, if you recall?
My recollection is the State Securities Board the first time around.
So that one went off as you have described in your testimony. And then did you learn that there had been a second open records request, this time to another agency that was present in the search, this time DPS?
Yes.
All right. Had you had conversations in the past in which the Lieutenant Governor expressed his views of DPS?
Excuse me, I think you mean the Attorney General?
Pardon me,
You said the Lieutenant Governor? I am listening very closely, Counselor.
that was only to see if you were paying attention, sir.
Trust me, I'm not missing a word.
Now that you've confirmed that you were, let me rephrase it. The DPS, I'm a little flustered here. I'm going to have to recover. So would this then, the second agency that had been involved in the search of Mr. Paul's house and business back in August of 19, was this now the second agency Mr. Paul and whomever is working on his behalf tried to get documents from?
That is my understanding. I was aware that this was the second time. I do not believe Meadows Collier was involved this time around. A new law firm had surfaced.
Yes. And do you recall whether the name of that lawyer?
I believe it was Gregor Wynn.
And was the lawyer you were dealing with, Mr. Michael Wynn?
He was part of that firm, to my recollection, yes.
Now, so how did it come to your attention as to what you were supposed to do, or what you were regarding, rather?
My understanding was this request was again for law enforcement materials, this time in the possession of DPS, not SSB. But again, these were all agencies part of this joint law enforcement operation. So very similar materials were being requested, again, relating to Nate Paul.
So how did you get dragged into it as to your position and your participation?
Primarily by assisting Mr. Vassar, who was at that time very, very new to the role.
All right. Can you describe for the jury the sequence of events as it was being considered in the Attorney General's office to override past decisions on these same matters?
Objection to leading, Your Honor.
I don't.
Sustained, rephrase.
Let me put it this way. What happened next?
Many things. So this request was submitted to DPS. DPS then did what it normally would have done, which is request a ruling from our office, from the Open Records Division, which was per normal process. At this point, the Attorney General became interested in the file once again.
And how did he show that interest?
He asked to meet with Justin Gordon. I believe it was at this point where Justin Gordon was summoned to the Attorney General's office to have discussions with the Attorney General about this file. And he also asked for a copy of a book that we keep in our office. We have a manual that we publish. When I say we, the Attorney General's office, every 2 years, I believe, publishes an update to the Open Records Manual to reflect changes to the code from the previous legislative session.
Did you provide him the book yourself?
It was either I or Ryan Vassar. I do recall we were looking for a copy in the office because he wanted a paper copy. Right. And the copies we had, the pages were falling out, so we had to go make sure they were all there.
Now, did you begin to continue to have repeated conversations with the...
Objection to leading.
I don't think that's leading at all. I haven't even finished, by the way.
Your Honor,
it works better if I finish the question.
Finish the question first.
Thank you very much. Did you have any continued conversations with the Attorney General about this matter?
My conversations were primarily with Ryan Vassar and Justin Gordon at this point, assisting them in handling it. I did overhear conversations. I know I did see and witness the Attorney General pull Justin Gordon into his office concerning this matter. So I was keenly aware, being on the 8th floor and working with my colleagues, that this was happening.
Did the Attorney General himself contact you about his interest in trying to find a way to reveal this information?
I do not recall specific conversations with him about the second request. And again, that would have made sense because I was no longer overseeing that division directly.
Then did you have any participation and observation of what happened next, or was that primarily in the realm of Mr. Vassar?
I did have some observations, and I did have some participation in what happened next.
In what way? What was it?
There were a couple of options on the table for how to handle this open records request. There really are two options. One, you either do a pour out. A pour out is when you more or less tell the agency you have to disclose the information, or you sustain the agency's request for exemptions. It was clear to us that the Attorney General was now stridently in favor of finding a way to disclose this information.
Objection to speculation.
Were you aware of what his position was?
Yes, I was personally aware of his position on this.
How were you personally aware?
Because I was in the office, I watched him as he was conducting himself. I overheard conversations of which he was a party concerning this. So yes, I was aware based on my interactions with him.
And how would
Judge, I'd renew my objection to
I
speculation.
think these are all party admissions, every single one of them, Your Honor. I mean,
I'm sorry.
These are conversations.
I did not hear you.
I'll wait
Jeff.
and let him ask the question. I'll retract my objection.
Continue.
So then, when you heard those conversations, what did you hear the Attorney General say? And who was he talking to?
Well, there were always groups of us on the 8th floor. It's very hard to hide on the 8th floor. It's a very small floor, and it's a square or a rectangle. And so there's not a lot of, and my office was directly down the hall from his. So I was very close to his office. And the summary of it was he was desirous of finding a way to either disclose that information or at the very least not rule against the requester.
What was the recommendation that you were aware of all the deputy in charge and the people above him, below him? What was their recommendation as to what should be done with the request of the
Objection to
EPS?
hearsay.
I was
Objection.
Sustained.
Were you present when they made their recommendation to the Attorney General?
I was personally involved in formulating a recommendation, yes.
All right. Did you yourself make a recommendation to the Attorney General?
I do not recall if I made the recommendation, but I certainly helped my colleagues
Objection and
formulate it.
non-responsive.
Wait a second. You've got to
Objection.
let him finish the answer.
I'm
You
making
can't
an objection.
do that.
I'm objecting.
Stop. Please stop.
I had an objection.
No
Your Honor.
arguing. No arguing. What was your objection?
My objection was that this witness answered counsel's question, and then the latter half of his answer was not responsive. And so my objection is not responsive, Your Honor.
The objection.
Overruled. Continue.
Thank you. Go ahead. I think my question to you was, did you yourself make a recommendation to the Attorney General, or were you present when others made a recommendation to the Attorney General to where you could hear his response?
No.
All right. Did you have any conversations with the Attorney General after the period of time we're talking about?
Concerning this matter,
Yes.
not to my recollection.
All right. At the time, were you present when the decision was made that it would take no position?
I was directly involved in that decision.
And tell us about that and how that happened.
Certainly. We were evaluating options for responding to this open records request. It would have been, in my view, unconscionable to do a pour out. For all the reasons we discussed, the law enforcement exception has very strong public policy grounding in this state. The Attorney General, based on my involvement in this case, I knew was not going to tolerate anything
Objection
less
and
than...
non-responsive, Your Honor.
It is responsive. Excuse me. I think he's just finished.
Move
his
along.
answer.
An objection is, okay.
Go ahead.
I understood that he was not going to tolerate anything that was viewed as unfavorable to the requester. As a result of that, an option was developed to do a no decision or a no opinion, which was very unusual.
Do you recall who came up with that option for him?
It was a group of us, Justin Gordon, Ryan Vassar, and myself. In conversations, that opinion was ultimately, that approach was reached.
And what was your position as to whether or not the no opinion option was one that should be adopted?
I believed it was the wrong approach. I believe it was the wrong decision, but it was the best we could do given the place that the Attorney General was at the time.
And was that adopted to keep him from continuing to insist on the other? In other words, continuing to insist on disclosure?
It was the best answer we could reach that we knew would be accepted by the Attorney General at the time, even though I believed it was wrong.
Now, it's been suggested in this litigation the last day and a half that meant no harm was done, no benefit was given to Nate Paul by that. Do you agree with that?
No.
Why not?
Objection is speculation, Judge.
That's not speculation.
Overruled.
Yeah, thank you.
There was at that time pending litigation concerning the open records request. We were being asked at the same time to issue a ruling on that request. It was my view that the ruling should have denied access to those records. That at least would have been persuasive authority for the court that was examining that very same issue. We had a policy at the AG's office that we would not withhold making a decision based on pending litigation. So, in effect, our no decision contravened our existing policy.
And in addition, did it provide any advantage in the potential advantage to the litigant, Mr. Paul, even though you weren't recommending disclosure, by recommending no opinion, do you have any idea as to whether or not that still conferred a benefit on him?
Yes.
And what was the benefit?
As a logical inference, anytime our office is the authority on open records decisions. If our office refuses to take a position, which, by the way, is deeply out of character and contrary to our precedent.
Objection and non-responsive, Your Honor.
Let him finish the answer, then you can object.
Continue, you may answer.
If our office refuses to take a position on an issue like that and the court sees that, that is a strong signal, I believe, to the court. And I've been a lawyer for over a decade, probably close to 2. That's a strong signal to the court about the Attorney General's view of that file, that we would have gone out of our way to render a vastly uncharacteristic decision.
Okay. Now, after that happened and that no opinion about it occurred, did you have any more contact with the open records request that Mr. Paul was making?
Once the no decision was issued, no.
All right. And then what was the next contact you had with matters of Mr. Paul?
It was in June. I believe it was in June. It may have been in May, but it was in that time period, late May, early June 2020. The Attorney General approached me personally and asked me to review a file that was, it was a lawsuit that was pending between a charity, the Mitty Foundation, and World Class Holdings, which I very quickly recognized as one of Nate Paul's company.
Had you had a history, even your previous jobs or even this one, overseeing the AG's position, the office's position of charity trust?
Yes.
Would you tell us what basically, by both statute and mission, was the obligation of the Attorney General's office as it involved charity trust?
Generally speaking, and this is true for most attorneys general's offices that have this jurisdiction, you are there as the Attorney General to protect the public interest in charity, which means that the public has an interest in ensuring that charities that are formed pursuant to state law are fulfilling their function to benefit the public interest, meaning the corpus of the proceeds the charity manages and operates on are not being squandered or wasted, that the charity is not being hijacked for improper purposes, and that is generally discharging its role to benefit the public. So that's the Attorney General's role, is to intervene in lawsuits, to participate. And by the way, we have authority to investigate charities that are abusing their role. The Attorney General's office protects the public interest in charity.
Under the law and the responsibility and the mission of the Attorney General's office, is the Attorney General's office in a charity trust case supposed to be intervening in any way to help one individual or the other?
The Attorney General's office is to intervene to advance the public interest in charity. So it is not characteristic to intervene to assist a party in particular. Rather, the intervention is for the purpose of defending, protecting, and ensuring the public interest in charity.
So if, in fact, a set of facts or course of conduct in making the decision to intervene would benefit the opposing party in the litigation to the charity trust, what would you expect the position of the Attorney General's office to be?
Under that hypothetical, if we were being asked to intervene to aid a party that was actively seeking to harm a charity. We should not intervene under those circumstances.
Well, in the case were you aware, did you become aware of the Mitty Foundation?
Again, I did become aware of the Mitty Foundation. The Attorney General personally brought the issue to my attention.
And when did the Attorney General bring that matter to your attention?
It was either toward the end of May or the beginning of June. It was sometime in that time frame.
How did it happen that he brought it to your attention?
He asked me to review the file and consider whether or not there was a basis for our office to intervene in the litigation pursuant to our statutory authority.
Is that the third time you've now been asked within 6 months to review a matter that involved Nate Paul?
Yes, yes.
So at this time, how would you characterize your feelings about whether or not the AG's office ought to be getting involved in anything that involved Nate Paul?
My feelings were that I was becoming increasingly concerned because the initial foray into the world of Nate Paul was through the Open Records Division. That had ended with the issuance of an uncharacteristic opinion. And now it had, in my view, metastasized to a new section within the Attorney General's office that had nothing to do with open records. This was a completely new front. It had nothing to do, by the way, it had nothing to do with the criminal investigation.
Objection to narrative and non-responsive.
I'll ask him another question.
I sustain the objection.
Thank you. When you were asked to look at this, where and when was that?
Early June.
And how and where did it occur?
In the office on the 8th floor.
And who was present for the conversation?
Based on my best recollection, it was just the two of us. I believe it happened in my office on the 8th floor.
When the Attorney General came into your office, what did he say and what did he want?
He wanted me to review the litigation file and evaluate whether or not there was a basis under our statutory authority to intervene.
At that time, had you personally met Mr. Paul yet?
No.
And so how long did this conversation with the Attorney General who asked you to look at the file take?
My recollection is it was very brief. I got the name of the case file from him, just the basic identifying details so that I could locate it, and then after that, he left.
All right. Did you, once you got the file, did you review it?
I reached out to a gentleman named Joshua Godby, who at the time oversaw our financial litigation division. I wanted him to at least help me evaluate this request because it was his division that had primary responsibility for deciding whether or not to intervene.
Did the Attorney General tell you what he wanted you to do at this time?
Beyond just the desire to review the file to consider intervention, no. It was very straightforward. Consider this for intervention.
How long did you talk to Mr. Godby, and afterwards did you review any materials, or did you stop at your conversation with Mr. Godby?
I asked Mr. Godby to provide me background on the case. I learned through those interactions that we had actually waived on the case months before.
All right, so at that time you became aware that y'all had taken a position previously not to intervene in the lawsuit?
That's what waiver means. When a notice is sent to our office per statute, if there's a charity involved in litigation, they're required to notify our office of that and give us an opportunity to intervene. We'd received that notice and we had issued a declination, a waiver.
In your conversations and research, did you discover when it was chronologically that the office had previously declined to enter the litigation at all?
My recollection, it was early in 2020, perhaps as early as January.
All right. And so after that declination, what did you learn? What was the occasion for this issue coming back before you?
My impression was it was the Attorney General asking me to review the file. And
at that time, did you discover how long the litigation between Mr. Paul's companies, therefore Mr. Paul, and the Mitty Foundation, how long had they been in litigation by that time?
It had been a long and sordid affair, yes. Lots of litigation had taken place.
And was it more than 1 year?
I believe it was more than that. I'm testing my memory, but it had been well, the case file was well developed.
All right. So at the end of the time, once you talk to him and once you talk to Mr. Godby and you've reviewed your other materials, what'd you do next?
Well, I notified the Attorney General that we had waived. We had previously waived on the file.
And did you have a recommendation as to whether you continued that waiver?
Either at that time or subsequent to that, I did. I had looked at the file. My strong belief, and by the way, this is very common, we rarely intervene because oftentimes the factors for intervention
Objection
are
and
not met.
non-responsive.
Let me ask you, what was your opinion after you talked to Mr. Godby and looked under the circumstances? By the time you talked to the Attorney General, what was your opinion as to what you should do?
There was no basis for us to intervene in the case.
Did you have that recommendation to the lieutenant? I mean, did you have that?
I would object again.
I'm not
here,
suicidal,
Counselor.
Your Honor. I'm not, I promise. Did you have that, did you share that opinion with the Attorney General?
My recollection, yes, I did share with him what had happened. The waiver had been filed, and the reason for the waiver was there was no basis for us to intervene.
What was the Attorney General's reaction?
He was not happy with that response.
How did he show he wasn't happy?
He informed me that he was surprised and not happy that we had waived. He wanted me to reconsider the waiver. He informed me that, in his view, it was improper for a charity to be oppressing a business, especially when the charity was effectively a limited investor in the business. He thought that was out of bounds for a charity to do that. And it was his view the litigation was somehow a form of oppression by the charity toward the business.
So if one were to ask, had he taken a clear-cut position on one litigant against the other in the case?
He was determined for us to intervene, and the basis for that was he was concerned that the charity was doing wrong to the world class.
And did he express any kind of feelings of himself against Mr. Godby's thus far resistance to entering the litigation?
Yes, Mr. Godby was resistant to entering into litigation. He and I had many conversations to that effect. We were both in agreement that intervening was a poor choice and was not justified by the circumstances.
It was the position that made its way to the Attorney General.
Yes.
How would you describe why you and Mr. Godby had concluded that you should not change the earlier decision and should not intervene in the lawsuit?
The charity was represented by competent and able counsel. It was taking legal positions that we believe were justifiable. It was largely, from our view, doing well in the litigation. The litigation involved a request for World Class to produce books and records concerning the investments the charity had made, and World Class was refusing to provide those, which any good corporate lawyer knows is improper. And so the charity was defending its interest in its investment aggressively and appropriately.
And was the charity itself simply seeking to find out what the value of their investment was?
Yes. Among other things, yes.
And among that and others. And whatever expenses had been incurred, when y'all looked at the file, who was causing the expenses?
The litigation had, when I earlier said it was a long and sordid affair, what I meant by that was World Class was rapidly burning through law firms. It had developed a history of using law firms, not paying their bills, cutting them loose, going on to the next law firm. So it was using law firms at a frightening rate. It was filing a number of motions. It was resisting discovery into its books and records.
Objection or non-responsive.
No, it is responsive. That's exactly what I'm asking. What was happening with the assets, and which one of these two parties was causing the expenses?
To our witness, just try to answer the questions directly moving forward.
Yes, Your Honor.
All right. Now, at the end of the day, would you describe the dispute being a minority investor invested with a company, Mr. Paul's companies, and they can't get any books or records to tell them what the expenses are, what the value is or so. And so there's a lawsuit. Is that a fair resolution? Fair description?
That is my understanding of the basis for the
All
lawsuit,
right.
yes.
And so when all this was going on, once you told the Attorney General that you and you agreed with Mr. Godby and you should not interfere, what happened?
He effectively directed us to intervene.
Pardon?
He directed us to intervene.
He instructed y'all to?
Yes.
So did he interfere in a lawsuit? Did that ultimately turn out to be on the side and effect of Mr. Paul?
Objection to leading.
How did it
Sustained.
All right. How did it end up? I mean, was there anybody that benefited from that by the fact that the Attorney General's office came in?
Yes.
Objection to speculation and an improper opinion, Your Honor.
Sustained.
Well, you clearly, though, knew what the result was going to be, did you not?
Objection to improper opinion and
Excuse me,
speculation.
just let me finish, please. The question.
Let him finish the question.
Judge.
Thank you. When you were opposed to the intervention, whom did you believe would benefit from the intervention?
Objection to speculation and improper opinion.
I've asked what his opinion is. That's very relevant here.
And I'm objecting to the opinion.
Excuse me.
Overruled.
Thank you.
Having
Whom
had
did
deep-
you believe would benefit from the intervention?
It was clear to me that the intervention.
Keep your microphone, please.
It was clear to me the intervention would benefit World Class Holdings and Nate Paul.
All right.
There was no question about that.
And what was your position expressed to the Attorney General as to whether that was appropriate or not?
It was not appropriate.
All right. In spite of that, there was an intervention?
There was an intervention. I was directed by the Attorney General to do so. I instructed Josh Godby to make the intervention. We justified it on the basis that we would intervene for the purpose of bringing the parties together for a mediation. That's honestly how I put lipstick on that pig.
What was your knowledge as to where there'd already been one mediation that was unsuccessful?
Yes, there had been.
Had there been an agreement previously?
Yes.
And do you remember how much at that mediation that there was an agreement for that the Mitty Foundation would receive?
Yes.
How much was that?
My recollection was around $10 million.
And then was that agreement breached?
Yes.
By whom?
World Class.
And by the time that y'all were asked to intervene or instructed and ordered to intervene, what was the status of the litigation?
The Mitty Foundation was pressing, based on my recollection, they were pressing hard for discovery into World Class, and World Class was approaching a point where they were risking sanctions for discovery noncompliance.
What was your experience both then and later that even has to do with this case in terms of, was there a particular consistent approach of Mr. Paul whenever he got into civil litigation as it applied to discovery?
He resisted it strongly based on what I could tell from the file.
All right. And so what did you do in terms of your position in the office after you were instructed to intervene?
I advised Mr. Godby of the decision to intervene in the case. The basis for that intervention would be to formulate a mediation to bring the parties back together again. Again, that was a post hoc rationalization. And we began speaking with the parties involved in the lawsuit.
Did you have any reason or belief that that was going to be successful?
No.
And ultimately, was it successful?
No.
And was there another final thing that you were instructed to do with the case that ended up with you being not involved any longer?
Following our intervention, Mr. Paxton, the Attorney General, asked if we could also file a motion to stay the proceedings.
Would that have stayed the discovery?
Yes.
And how was it that you knew that's what the Attorney General wanted to do?
He conveyed that to me himself.
What was your reaction?
I could see no justification for that. That would have been directly against the public interest in charity and directly for the benefit of only one party, World Class.
Did you inform the Attorney General of that?
I told him that I was very uncomfortable filing a motion to stay and resisted it, yes.
So what was his reaction to that?
He was not pleased with that. I was subsequently removed from the file by Mr. Mateer.
And did without going into what he said, what was your understanding as to why you were no longer going to be there with the file?
My understanding was that Mr. Mateer believed that I was wasting time dealing with Nate Paul, and that I needed to stop wasting time dealing with matters concerning Nate Paul.
So then, after that, were you opposed to being removed from that file?
I was very happy to be removed from that file. I was quite frankly sick of dealing with Nate Paul.
Did you do anything like the equivalent of a high five or go out and visit, have a nice dinner or anything?
I was very relieved.
Okay. And so at the end of the time when you left that file then, was that it, the rest of your professional career? Was that your last contact with anything having to do with Nate Paul?
No.
When is the next time that Nate Paul appears on your radar screen?
So this is the summer of 2020. We are still working around the clock on COVID matters, which was my primary focus. And in late July, again, Mr. McCarty and others had taken over the Mitty Foundation file. I was approached by the Attorney General again, this time to evaluate a matter related to COVID, and in particular the governor's order, I believe it was GA 28, it was one of the closure orders, as it pertained to foreclosures of real estate.
Now, at this time, did you have any idea or any inclination at all that this also was going to involve Mr. Paul?
No.
Do you recall approximately when you say in the summer, I think you just said July now, because it's September and it's hard to tell this between July. Did you say July 31st or was it earlier than that?
It was earlier in the week, yes.
All right, and how did the Attorney General contact you and what did he want to know?
He came to me in person and he asked me to evaluate whether or not foreclosure sales should be allowed or could be allowed to continue given the current state of the governor's COVID orders.
All right. So now we're in late July. The governor's orders roughly come out at the middle of March of that same year, correct?
And they were continuing to come out thereafter.
There would be periodic orders issued. Did the Attorney General express any interest in what he wanted to happen?
Not at first, no.
All right. So did you do anything in response to his immediate question?
I did not.
And why was that?
It was sort of an offhanded request, and we were busy dealing with a whole litany of matters related to COVID. It was also one of those sort of, hey, take a look at this type of request. There was no real time frame associated with it, so I put it on my to-do list, but it didn't get high priority at that moment.
And then when was the next time he contacted you about it, if he did?
A few days later, he approached me and wanted to know if we had done the research and it was completed.
Do you recall which day of the week it was he approached you?
I believe it was Thursday. Yes, I believe it was that Thursday.
And what did you tell him?
I said no, it was not.
All right. So then did he say anything further?
Yes, he said, get on it. We need to get this done right away.
Did he express what he meant by right away?
He said this needs to happen within the next few days.
And that was on a Thursday?
Yes.
Well, the next few days takes into a weekend, right?
That's right.
Did he express why he needed something done that weekend?
He did.
What did he say?
He said that homeowners across Texas would benefit from an opinion dealing with foreclosures.
Now, you don't know anybody else is going to benefit from this. What was your reaction to that? Did you believe that it really was focusing on homeowners?
Overruled.
Objection. Okay.
Overruled. Answer the question.
I quite frankly wasn't quite sure what to think about it because I was scrambling to pull together the research. I had no basis to know whether or not homeowners would benefit or not.
All right. So did he provide you any evidence or anything to help you understand whether this was really about helping homeowners or not?
No, but he did. I did ask him directly if there was someone I could speak to who was cognizant of the issues or perhaps had even made the request.
What did he tell you?
We were standing in the hallway of the 8th floor.
He stopped you? What day?
This was Thursday, I believe.
All right.
Yes.
Go ahead.
We were standing out in the hallway, and I asked him if there was someone I could speak with who had knowledge of the request.
Now, let me stop you there. Let's explain to the jury as quickly as we can why that was relevant. What is the law that would require you to have some type of requester?
Well, the law, based on the Government Code 402, I think it's 045 or thereabouts, our office is not allowed to issue opinions to individuals unless those individuals are called out in the code specifically.
And did he give you any suggestion as to who was asking for this or who wanted it or anything?
He did. He went back to his office and returned in a few minutes and handed me a scrap of paper with a phone number on it.
And did it have a name as well as a phone number?
I can't recall, but I recall the phone number for sure.
So what did
if it was the name, it didn't ring a bell.
What did you do with his phone number?
I put it in my pocket. It was toward the end of the day, and committed to call the phone number that day.
What, on the way home or what?
It was late. We were pulling very late hours at that time because of COVID. So I do recall it was in my pocket. I was dealing with some other exigent circumstances, and I recall pulling into my driveway that evening. It was dark, so I got home very late.
So did you call this guy?
I did.
And tell us what happened.
Objection to hearsay. This question calls for hearsay, Judge.
Well, actually, this isn't offered for the truth of the matter. This is simply an operative fact of this particular event, Your Honor.
Judge, he's asking
We're
specific.
we're
Stop.
excuse me. go ahead.
Sustain. Rephrase.
Did you call this guy?
I did.
And did he answer?
Yes.
And did you have a conversation?
I did have a conversation.
And did he know anything about what you were calling about?
Objection to hearsay.
That is not
He's
hearsay. Your Honor.
backdooring hearsay, Your Honor.
Excuse me. It is not hearsay.
His question insinuates an answer from this individual, which would be hearsay,
It doesn't
Judge.
matter. Hearsay is a communication. This is whether he did not answer. I did not
Sustained.
ask him if he communicated. Thank you. Well, did you find out whether this guy knew anything about it?
Objection, Your Honor, to hearsay. You sustain the objection.
Surely the question of did you find out whether this guy knew anything about it is not hearsay, in all due respect.
It's the same conversation, Your Honor. It's hearsay.
I haven't asked him, Your Honor, what the conversation was. I haven't asked him what the person said.
Just answer yes or no to the question, not go into the contents of the conversation.
Could you please restate the question?
I ask you, well, did you find out whether this guy knew anything about the matter that you were calling about?
Judge, I'd re-urge my objection
The
that...
judge has already ruled. Would you answer yes or no?
Judge, I'd re-urge the objection that it is hearsay. Anything...
He can answer yes or no.
Yes, Judge.
That's it.
I did learn whether or not this gentleman knew anything about the file.
All right. So as a result of what you learned from that conversation, did you go then back to the Attorney General? Or contact him one way or the other?
I returned to the Attorney General to seek additional assistance because I still had no assistance.
All right. And what did you tell the Attorney General, and what did he say to you?
Well, I went back to the Attorney General, and we still did not have an authorized requester under the code.
Did you tell him that this guy didn't know anything about it?
Objection, Your Honor, to hearsay.
No, excuse me, let me be
This
heard.
question is...
Let me be heard,
The
please.
form of this question...
Stop arguing with each other.
Let me
Finish
be
your
heard,
objection.
please.
Your objection is?
The form of Mr. Hardin's question is hearsay. He is insinuating and stating hearsay in his question.
The difference is he's in the presence of the Attorney General, and we're about to have, by an acquiescence by silence in this, and it is not being offered for the truth of the matter. It's being offered the fact that he told the Attorney General, which then influences the Attorney General's conduct following.
Judge, he's backdooring hearsay through a witness that the witness hasn't even stated his name.
Sustained, continue.
May I be heard briefly? I just wanted to point out one thing. I'm not arguing with you at all. It's important to understand that when we're talking about hearsay, this man is the witness. Hearsay is designed to prevent people from coming into court and repeating something that can't be cross-examined. This man can be cross-examined about the conversations that he had previously, but more importantly, he's there having a conversation with the Attorney General. The Attorney General is the one who sent him on the mission, and the Attorney General, by acquiescence, is acceding to the comment. And when you put all that together, I'd respectfully ask the court to reconsider.
And Your Honor, we're talking about a conversation with an unnamed witness on an unknown number on a sheet of paper we don't have. This is hearsay.
Try rephrasing the question one more time. Would you rephrase the question one more time?
Thank you, Judge. When you talked to the Attorney General, what did you tell him about your conversation, and what was his response?
Objection, hearsay, Judge.
Overruled. Continue. Answer the question.
Thank you.
I shared with the Attorney General that the random number he had provided me and the gentleman had yielded no helpful information to me whatsoever.
Did he know anything about what you were calling about?
The Attorney General?
No, the man you called.
No.
All right. And so when you told the Attorney General that, what was his reaction?
He shrugged it off and said, well, let's proceed anyways.
All right. Well, so you went and searched then for a requester, did you?
I enlisted the assistance of Ryan Fisher.
All right. So now, what would you need to be able to render this opinion that the Attorney General had requested?
Well, if we were going to issue an opinion to an individual, we needed someone who was authorized to make a request to our office.
All right. And were you ultimately informed that Mr. Fisher had, without going into what he said one way, located a requester?
Yes.
And who was the requester?
Senator Brian Hughes.
All right. Now, I want to be very clear. Do you have any evidence from any source or any reason to believe that at the time Senator Hughes was asked to be the requester, that he had any idea that that would benefit any particular individual at all?
No.
All right. And we're now 3 years later. Would it be your opinion that Senator Hughes had no idea that the request he's making might be used in a way that wasn't appropriate?
Objection to leading an improper opinion.
You have to let me finish the sentence.
The call of a-
Excuse me, sir. I want it in the record. I finished the sentence. He could object, and the court could
Finish
rule.
the sentence. Finish the sentence.
Thank you very much. Even then or since, do you have any belief that you yourself, that Senator Hughes had any idea that by being asked to be a requester for an opinion, that opinion was going to be used to either help or hurt anybody else?
No, no basis for that.
All right. And of course, was Nate Paul's name ever mentioned in this at all?
The Attorney General studiously avoided using the name Nate Paul.
Objection to improper opinion.
All right. And
Speculation.
then
I'd ask that I'd ask that the objection be ruled on, Judge, and to strike this witness testimony based on the ruling.
Overruled.
All right. Now, when you then, what was the mission you were then going to have to do? After you got the request from Senator Hughes, and was the request done by text or what? Or did you have any contact with him or just with Mr. Fisher?
I did not personally have any contact with the senator, no.
All right. And so then what was your mission? What was your obligation to do?
My assignment was to prepare the opinion with the assistance of Deputy for Legal Counsel Ryan Vassar.
How were you going to do that? What were you going to do?
I assigned the research to Ryan Vassar. He began the process of researching on Friday, and the plan was for him to send me a draft the next day.
All right.
Saturday.
And when he did, what time of day, well, when did y'all start conversing? Did you have conversations with him on Friday night?
I did speak with him on Friday, yes.
Who was doing the drafting Friday night?
Ryan Vassar.
And what were y'all doing about drafts?
Ryan Vassar was preparing the initial draft, and then he would share it with me by email.
Now, was the Attorney General involved in this process at all?
Initially, no, but subsequently, yes.
When did he become involved?
Saturday.
And what happened Saturday that ended up getting the Attorney General involved?
After we completed what we believed was a satisfactory draft, we provided it to the Attorney General by email.
And when you did so, would you estimate what time of day it was?
It was late morning, if I recall correctly.
And what conclusion did you and Mr. Vassar reach as to what the answer should be?
Generally speaking, no, that the governor's orders would not prevent foreclosure sales from going forward.
And I'm not sure we've made clear just exactly what the mission was. What issue were you researching and going to issue an opinion on?
Whether or not the governor's COVID orders would preclude foreclosure sales from taking place.
And was there a limit? Was it a location?
My recollection, and again, it's been a while, is that these foreclosure sales generally happen in person on a certain day of the month. And there was a question as to whether or not guidelines governing the number of persons who could gather in one place would prohibit or restrict a foreclosure sale from going forward.
And the issue of the numbers of people as to whether they could gather here was what? Do you remember the numbers?
Oh, the governor's orders?
Yes.
There were county, city orders, the governor's orders. The number 10 sticks in my mind, but that was my recollection.
And were these foreclosure events to occur outside?
Yes.
What had been, as of the July 31st, August 1st time frame, the Attorney General's office's position and the Attorney General's position himself as to whether events like this should be open?
Ideologically, we were vastly in favor of openness. We were looking for every opportunity to signal to the public that Texas should be open for business.
So if one were to close those foreclosure events, would that have been consistent or inconsistent with the position that the Attorney General's office and the Attorney General himself had been taking in the months before July 31st and August 1st?
Objection and proper opinion.
Excuse me. He's entitled to express whether...
Overruled.
Thank you,
Overruled.
Judge. Thank you.
It would have been contrary.
All right. Now, the opinion that you reached, what did you inform? Who called the Attorney General or whatever communication you used to let him know what your position was?
I emailed him the draft that Mr. Vassar had prepared and that I had reviewed.
And at that time, who signed the draft, or was it signed at all? Was it still a draft?
Still a draft, although if my recollection serves me right, it was set up for Mr. Vassar's signature.
All right. And so, and your conclusion was that you notified him of him in that draft was what?
Generally speaking, foreclosures could go forward.
All right. And then what response did you get from the Attorney General?
At some point that afternoon, he informed me that that was not...
What time of day and how?
Mid-afternoon is my best recollection.
What did he tell you?
That was not the answer that he wanted or that he was looking for.
So what did he instruct you to do?
The opposite. Do the opposite.
Do you recall what he said?
It was effectively, this is not going to work. We need to do something very different. We need to write this a different way so that foreclosure sales don't go forward. And of course, he repeated his mantra about helping homeowners in Texas. And of course, at that point, I understood sort of what his argument, I could understand why he was arguing that, but he did say, let's reverse it and go this direction.
Let's reverse what?
The opinion that we had reached.
And so what did you and Mr. Vassar do?
We wrote it the way that the Attorney General had asked. I specifically asked Mr. Vassar if it was an 80-20 or 90-10 proposition, if it could pass the laugh test, and he thought he could write it in a way that would pass the laugh test.
And when you, had you begun to wonder why he was so involved in this?
It was very uncharacteristic for the Attorney General.
Pardon me?
It was exceptionally uncharacteristic for the Attorney General to be involved in an opinion like this.
Now, so what did you guys do to go draft the opposite opinion that you just delivered?
I assigned it to Mr. Vassar, and he got to work.
And how did y'all get to work? What were the next 7 or 8 hours like?
He prepared the draft. He sent me the draft. We edited it. I had provided it to the Attorney General that evening, He had some additional comments and requests for changes to the opinion. We worked past midnight.
How many times did you talk to the Attorney General?
Several.
Did the Attorney General initiate calls with you during this period of time?
Yes.
And if you had to estimate, how many times did the Attorney General reach out to you about the language of your opinion and what he wanted in it that night?
Multiple times. It was at least 3 or 4, probably more.
Would the phone records of going back and forth from your numbers be the best judgment? If they're not, if the phone records show calls that particular
Objection to
night,
leading an attorney
Excuse-
testifying about facts, not in
excuse me, I
evidence.
still get to finish the
I'm
question.
objecting to the line of questioning.
Excuse me.
Overruled.
No. How many times did the Attorney General call you with suggested language?
Several.
And then when he did that, were you at any time going back and initiating calls to him?
Generally speaking, I was calling Mr. Vassar, and yes, I do believe I called the Attorney General a few times, if I recall correctly.
All right.
Counselor, we're going to are you in a good position here, say another 5-10 minutes? Is that a good break point, or do you want to
Sure,
break now?
that'd be fine. I'm not going to be able to finish, I'm afraid.
Right, I assume you'd be back to, so 5 or 10 minutes?
Sure.
Is that,
That's great.
All right.
That's perfect. Thank you, sir. All right. Now, on this particular issue, what time in the morning did you guys complete the opinion giving the Attorney General the result he wanted?
It was after midnight.
Okay. And by the time midnight came around, how would you describe the Attorney General's conduct that night in terms of his involvement with you?
It was bizarre.
And why was it bizarre?
He was acting like a man with a gun to his head.
In what way?
Anxious, desperate, urging me to get this out as quickly as humanly possible. I was very concerned
Objection to
by his
speculation, Your
behavior.
Honor. He's speculating about what Mr. Paxton felt at the time.
My question is directed toward his reaction and observation as to the way the Attorney General was acting.
overruled, continue.
Go ahead, sir.
All of those things. He was desperate to get it out quickly.
Objection to speculation,
Did you-
Judge, and improper opinion.
Overruled, Counselor.
Did he have a deadline for you guys? Had he told you when you wanted to get it done by?
It had to be done that weekend.
Pardon me?
It had to be done that weekend.
Okay, now you keep the microphone. I'm sorry. Now, when were you supposed to have it done? When did he give you a day? Because I didn't quite understand your answer before. I apologize.
Yes.
What
It
was
had
your
to be
de-
done that weekend.
That weekend. Did he tell you why?
He continued to repeat his mantra that this is going to help homeowners.
All right. And did he explain to you any homeowners were in crisis by Monday morning?
No.
Did you yourself start connecting any dots as to what this might involve as a result of all this?
I began to form an opinion, yes, about what was happening.
And what was that?
He had asked us to completely rewrite the opinion, to change the conclusion. He had done so in a whirlwind of activity.
Objection and non-responsive.
It's
He asked
very
about his
responsive.
opinion.
I think it's very
Overruled.
Thank you. Go ahead.
Based on those observations, I was very given the fact that there had been no profit from prior interactions with the phone number he gave me, I was very concerned that something more
Objection
was
to
going on.
speculation.
Let me ask you this. I didn't hear that last answer. I'm
I
hoping.
objected to speculation.
Excuse me. May I?
Overruled.
Thank you. May I point out, she can't get both of us, and it's just a nightmare for the court
I'm
reporter.
objecting to sidebar, Judge.
Excuse me, sir.
Excuse me, both of you. You're correct. She can't record 2 people at one time, so try not to talk over each other.
Yes, Your
Thank-
Honor.
Thank you, Counselor.
Thank you. Now, after that, did you learn of any particular event that involved Nate Paul that would indicate a potential benefit from the ruling that you ultimately issued?
Objection to leading and speculation.
I asked what he learned. It's not speculation.
He insinuated.
I'm going to sustain that one.
All right.
Rephrase.
Thank you, Judge. Did you yourself also find out anything about Nate Paul and foreclosure event?
Objection to relevance.
Oh, I think it's very relevant.
And speculation as well, Judge.
It's very relevant, and that's. I'm sorry. It's very-
Rephrase one more time.
Yes. Did you yourself ultimately discover a benefit to Nate Paul from what y'all had done?
Yes.
And what was that?
Objection to lack of personal knowledge. He has not laid the foundation to show how Mr. Bangert would have found this out, Judge. So lack of personal knowledge.
I don't know how, if he knows it and he learned it, he can then challenge how he learned it. He can challenge that. But whether or not he learned of a benefit to Nate Paul, I don't know what the objection to that is.
I'd be happy to take him on board higher, Judge.
I'll sustain it.
Now, ultimately, did you have any more, the opinion that you issued, you've explained that it was contrary to the law as y'all researched and issued your first opinion, correct?
It was not the best interpretation of the law by a long shot.
Had the Attorney General ever inserted himself in a particular opinion during the time you were there?
Objection to speculation.
No, it's whether he knows of any time ever the Attorney General had ever interfered with an opinion like this.
Overruled.
Thank
Next
you.
question.
I oversaw the opinion committee
Pardon me?
I oversaw the opinion committee for over a year, and in my time overseeing the opinion committee, he never interjected himself in that way.
During that year you were there, had he ever interfered with the conclusions that the opinion committee or anybody working in that committee had issued?
On occasion, he would have suggestions, but the degree of interference here was completely unprecedented.
Had you ever had him participate in the actual drafting of an opinion?
No.
In this particular time that you were talking to him, and were there any, on that Saturday, how many times would you estimate that he would call and ask you how much longer?
Toward the end, it was repeatedly. He would text me. If I recall correctly, he also called, but it was a constant stream of communications.
And did he ever send back to you some suggested change in language?
They were by phone call.
All right. Did he ever call and discuss any change of language?
Yes.
Had you ever experienced anything like that with the Attorney General?
I had not.
The final particular opinion, who initially signed it? At first, which one of the two of you signed it?
It was set up for Ryan Vassar's signature initially.
Did the draft have that for him to sign initially?
Yes,
Did you change that?
I did.
And how did you change it, and for what reason?
I changed it to go out under my signature.
And why?
At the end of the process, I had become very alarmed by the Attorney General's behavior. I had promoted Ryan Vassar into that position myself, and I felt a degree of responsibility to him. He was still building his career, and my sense was if something broke bad with this, I did not want it to tarnish his career.
I think that's a good place to stop, Your Honor.
Thank you, Mr. Hardin. We will adjourn until 9 a.m. tomorrow morning. Thank you.